Hi, so what is battered spouse syndrome? And will Sarah Boone use this as a defense at her murder trial? So, welcome back to La Belle Vie, the Good Life Network, and our law and crime content. So, by way of update in the state of Florida v. Sarah Boone case, the court yesterday had its pretrial conference. And the YouTube channel Recovery Addict actually had a subscriber there in person in the court. And she reported that Sarah's counsel was not there, nor was Sarah. He did appear via Zoom. Apparently, he had COVID and was just now recuperating. He also said that because of that, he hadn't had a chance yet to meet with Sarah in person. He also mentioned that he has a 3-week long death penalty trial that's going to begin in February. So something to keep note of as far as timing and potential future continuances. But then he also finally, Recovery Addict's subscriber also noted that he mentioned that the defense is considering the battered spouse defense. So thank you again to Recovery Addict and his subscriber for the in-person reporting. That was fantastic. So currently the final pretrial conference is scheduled for March 28th, with trial scheduled to begin on April 10th. As I mentioned, I wouldn't be surprised if this gets continued again, particularly since we now know that her lawyer has a 3-week death penalty trial in February. But I do suspect that the court is going to probably limit any future continuances because this case has been pending for so long. So getting to the battered spouse defense. Now, as I mentioned in my last video, I suspected they were going to bring this or pursue this because last January they had filed a motion to appoint a domestic violence psychologist as an expert, and here to specifically to assist the defense with the analysis of battered woman syndrome or battered spouse syndrome, also now more commonly referred to today, more modernly referred to today as intimate partner violence. But we will call it battered spouse syndrome only because that's how it's cited in the Florida rules, but it is really broader. It's not just someone that is married. It's intimate partner violence. So here, as we mentioned, they had indicated who the person would be, and that she couldn't afford it because she's indigent. The court did grant that motion back in last March. Now, it sounds like the work hasn't really gone forward in this on this since the defense is now saying they want to still consider it. So my assumption is that probably not a lot of work has been done, but it has been approved, the costs. And I thought the only thing that was interesting here was that it looks like this physician that the defense has named is out of state. And this is interesting that no providers with appropriate skills or expertise are available in the county in which the case is filed, so Orange County, and or any other county in the state of Florida, which seems odd. I would think that there would be some psychologist in the state of Florida that could advise on battered spouse syndrome, but in any event, that was what was filed. Now, again, this was filed from her previous attorney, Mr. Padilla. Okay, so I will be on the lookout for that. So what is battered spouse defense under Florida law? In Florida, it is an available defense, and it's recognized generally as a form of a self-defense. So it's kind of like a self-defense type of defense. And basically, in other words, to self-defense to justify the killing of another, the intimate partner. It can lead to what's called a learned helplessness, and where the victim becomes so kind of depressed and dejected that they kind of feel that there's no way that they can leave. They just have to stay. And it kind of explains why people would stay in a situation like this if it was so harmful. And then it's even actually cited in the CDC. So if you want to learn more about intimate partner violence, it's a very serious matter. They've even got specific sections for how to deal with teen sexual violence, all this stuff, teen dating violence. So in any event, it's, there's definitely a lot of literature out there. But generally speaking, it usually comes in a kind of a 3-stage process is what I've been able to learn from the literature. Is stage 1 is where the abuser engages in some behavior that creates a tension in the relationship. So maybe arguing or nitpicking or something that kind of is bringing the tension level up. And then the second stage is, I guess, the abuse stage. And that's where the abuser commits some form of abuse. And it could be physical abuse, it could be mental abuse, it could be verbal abuse, etc. And then the third stage is called the honeymoon stage, where kind of the abuser comes back and tries to fix things and get the person, the victim, back on their good side. So that's the 3 stages, and apparently it will just start to cycle and repeat itself, and to the point where the abuser, the person that's being abused, doesn't feel it will ever stop unless something kind of drastic happens or something major happens. And so the argument is that the defendant should be justified in committing that act here, murder, against their abuser because of the abuse that they themselves have suffered from at the hands of that person. So again, a self-defense argument. Now, what I think is going to be interesting in this case is how the availability of scope and who can be questioned. So under Florida law, so the scope of the expert testimony and who can ask what. So now in Florida, now this is assuming that they'll bring this defense, but assuming they're going to bring this defense, there is a Supreme Court case called State v. Hickson where the Florida Supreme Court basically put out a balancing test of what to do where you have the need for defendants to be able to bring this expert testimony to explain what this battered spouse syndrome is, but that needs to be balanced against the right of the prosecution to be able to cross-examine witnesses. And so what the rule that the court came out with was basically saying that an expert can generally describe the battered spouse syndrome and the characteristics of a person generally suffering from that syndrome and express an opinion based on hypothetical questions. But that opinion can't be based on an interview with the specific defendant, so here, Sarah Boone, as to the applicability of the defense to that specific defendant, unless, and here's the kicker, unless the reliance of that testimony is first provided in the notice to the other side, and the state has the opportunity to have its own expert witness interview the defendant. So that's where it's just going to be really interesting to see if strategically the defense is going to want the prosecution's expert to be able to interview Sarah. So are they going to limit, if they use this testimony, again, we don't know, they just gave a comment in open court that they were contemplating using it, and we know from the motion they were contemplating using it. But assuming that they go forward with it, what is the scope of that testimony going to be? Are they going to limit it to just generally, this is what the battered spouse syndrome is, and here's basically how it can play out, and not based on an examination of this specific defendant here, Sarah Boone? Or are they going to use the testimony of the expert and how the interview based on Sarah and the facts of Sarah's case? Then they've opened the door, and then the prosecution will be able to come in and have their own expert interview Sarah. So that's going to be what's interesting to see, and of course we won't know that for a while, but in any event, stay tuned. Finally, some quick technicalities of the defense under Florida law. I think I mentioned this before, but as mentioned, this defense does need to file a formal notice that they will intend to rely on this as a defense no later than 30 days prior to trial. So that's why, it wasn't going to happen this time, because the pretrial conference was on January 17th and the trial is supposed to begin January 30th. But in any event, we'll be looking out for that formal notice. I wouldn't say that an oral statement in court is enough. We'll be looking for a formal notice. But the notice also has to include a statement of particulars on how that defense is actually going to be used based on the facts of this case, and also the names and addresses of any witnesses, if any, that the defense will use and as part of that reliance on that defense. So again, I'll be on the lookout for that formal notice to see when that comes. But in the meantime, I think we have some time now that the trial's been moved to April. So I'm going to be doing one more video about some of the other motions that have been filed thus far in the case in the past couple years. Mostly it's motions for various types of experts, but I think it's interesting because it might give us a sense of other potential defenses or what the defense strategy might be. There was also an initial list of some discovery that the prosecution provided. So I'll go over those in one more video, and then of course I will keep looking and keep updating on the docket to see if anything happens between now and March 28th, which is the day of the final pretrial conference. And I'll give an update. But in the meantime, thank you again so much for joining, and I hope to see you in my next video. Bye.